I had to go 2 miles down the road, turn around and get back in line. I said, well, that didn't outsmart that, did it?
You were trying to stop and I didn't last for
I know.
Like,
So, Miss Barbara,
yes.
what district do you represent?
Well, I'm Mike Barker's appointee, but I live down on 30A east of, or just east of Camp Creek Lake. So.
Okay, so. Okay, y'all ready to get started? Karen, are you ready? All right, y'all ready? All right, we'll bring the meeting to order. We'll start with the invocation and the Pledge of Allegiance. If you would please stand. Lord, we just thank you so much for the opportunities you give us in this great country and for the privilege of being able to join in our local government. We just ask you to give us wisdom and discernment and that we make the right decisions for the citizens of Walton County. In Christ's name we pray, amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, let's see, let's go over the minutes. Did everybody have a chance to read the minutes? Any changes need to be made? Are we good with them?
I make a motion that we approve the minutes from the last meeting.
A motion
I'll second.
and a second. All in favor?
Aye.
All opposed? Okay, motion carried. You pass that around. You pass that around, sir. Okay. Kristen, you ready?
If you like, we can go ahead and take care of some requests for continuances first. The first item that we're requesting to continue is item number 2 on your agenda, the South Walton RV Resort Small Scale Amendment. There's a request to continue until May 13th, 2021.
Okay.
Action on those
Yes, do you want to do them? Yeah.
individually, yeah.
Yeah, we have a motion to continue.
I make a go ahead. I'll second it then.
All right, we got a motion and a second. All in favor?
Aye.
All right, motion carries.
The second item with a request to continue is item number 8 under the quasi-judicial agenda, which is the South Walton RV Resort. Request to continue until May 13th, 2021.
Okay, we have a motion. And a second? Second. Motion second, all in favor?
Aye.
Aye.
Motion carries.
Okay, and the final item with a request to continue is item number 10 on your agenda under the quasi-judicial heading, which is the Eden's Landing PUD Amendment number 3, and the request to continue until May 13th, 2021.
Okay, we have a motion
Make the motion to continue that.
and a second. All in favor?
Aye.
All right, motion carries. Okay.
All right, I'm going to have Stephen give you the update on Black Creek.
Okay.
Good evening, Stephen Schoen, Planning and Development Services. This is a large-scale amendment application submitted by Walton County Planning and Development Services requesting approval of a large-scale future land use map amendment from the Black Creek Special Planning Area to residential and mixed use and a zoning district change from the BCSPA, low density residential, and the BCSPA rural town center to urban residential and village mixed use. This is occurring on approximately 587 acres, generally located off of County Road 3280, and it's identified by the staff, by the parcel IDs in your staff report. If I could draw your attention as well to the handout you have in front of you, page 6. There was a change made after publication of the report, and I would like both that and the staff report entered into the record, if I could, please.
Okay.
Thank you. This isn't the first time you've seen this. I believe it came in front of you back in January for the first time. There was some stakeholder issues with the slight increase in density intensity. We have since then changed the urban residential and village mixed use zoning designations. The code anyways has gone through you and is now at the BOCC level, essentially carrying over that density and intensity into the proposed zoning and land use changes you have in front of you. I've spoke with the stakeholder groups and the property owners. They are okay with what we're proposing. I'd also like to draw your attention to a number of parcels there that you can see border 3280, the ones that abut that right of way. All of those parcels have requested the urban residential, the residential future land use, and the urban residential zoning designation. The property owners of the two northern portions will be going to village mixed use at their request. If you have any questions, I can go into further detail or answer them as you see fit.
I know there was some issues about the density getting higher in some areas, and that was resolved.
Yes, sir. Yeah, it's carrying straight across. It's a wash from what was there previously and what we're proposing.
Anybody else have any questions for staff? All right, thank you, sir.
If I can just make one more point.
Sure.
There is one change that you will see to these lands. There was originally a 30% open space requirement. Now there is a 25% open space requirement. Again, stakeholders and landowners are okay with that change, and it was carried through with the land development code changes that you recently reviewed.
Okay.
Okay.
All right.
Yeah, one question. All the stakeholders and landowners are on the same page regarding.
Yes, sir. Yes, as of yesterday, I spoke with everyone, spoke with everyone, and they all agree to what has transpired over the last few months here. Thank you. Yep.
I assume one of these stakeholders is the Negosi Plantation?
Yes, sir.
Okay.
Yes.
All right, I knew they had some issues they wanted to get resolved on that, so.
And they have been.
All right, thank you. Yep. All right, we'll open it to public comments.
And I'm here on behalf of Negosi, and yes, they have resolved all of our issues, and Stephen has done a remarkable job involving all the stakeholders, and we're pleased where it is.
Okay, thank you, sir. Anybody else like to speak on this? Anybody on Zoom want to speak on this? All right. Seeing none, we'll close public comments. And commissioners, what are your wishes?
Motion to approve.
We have a motion.
I'll second.
Second. Any other discussion? All in favor?
Aye.
Opposed? Motion carries. All right.
Commissioners, item number 4 is a revised interlocal agreement for public school facilities planning. This comes sort of after our comprehensive plan update in the 2018-2019 timeframe, where we removed public school concurrency from our comp plan following the Florida legislature's ability for local governments to do that. And in its place, you have this revised interlocal. This is something that we've been needing to do. It's very important to Walton County and to planning that we work with our school board partner and that we establish really good levels of coordination on development review, and that we, work to ensure that our schools keep pace with development. So this has been ongoing. Stephen's been working on it for a while with the school board and the school board's consultant, and they're here tonight, so they'll talk to you a little bit about what's in it. But this is something that's very, very important for Walton County and for the school system.
All right.
So Stephen, let me give a little brief about what's in the interlocal.
So I won't go into too much detail. I have provided a rather lengthy summary in your packet for you to see the real kind of hard lines of the change from the 2009 to the present day agreement. I would also like to say that Michelle Doggett and Gene Bowles and another member from the school district is here to to speak to you about any concerns you have or the meat of the issues, if you will, why these changes are being proposed. But Kristen really hit the nail on the head. It removes concurrency. It doesn't remove, the tracking. It actually implements some additional tracking mechanisms and more coordination between the county and the cities and the school board. So don't be mistaken that, we're not just saying, okay, do whatever. We're not going to manage that. We are in a better way, at least in my opinion. But I can answer any questions that you may have regarding the summary. And then I would like to introduce the school district folks to give you kind of a history of the agreement in general and then where we stand now.
Any questions for staff? All right.
All right. Thank you.
Thank you, Stephen. Michelle Doggett, Walton County School District, planner for the school district, and I also have here with me not only Jean Bowles, who is a consultant for the school district, but also Jill Smith. She's in the audience for questions too. A couple of years ago, the school district, actually in 2019, reached out to Jean Bowles to consult with him or actually hire a contracted consultant to help our planning program get back on track and be brought up to date. And one of those areas that needed to be looked at, reviewed, and then brought up to compliance was the interlocal agreement. And I do want to say that it's a good document. Not a whole lot of major changes have been made at all. And I want to echo what Kristen said. I mean, the county and the municipalities as well have all been really good to work with the school district. I mean, in my experience personally, and it's wonderful to be able to pick up the phone and if I have questions and reach out to those folks that I have questions for, and they're always so helpful. And this is just basically putting it on paper and just reflecting on what we're already doing, but just to make sure that we continue that, it is important that we all reach across the table and work together because we do have a lot of development in our area, as you know, first and foremost, and we feel it as well because we try to find, seats for those students that come in that are generated by all the, residents that are moving into our area. So at this time, I'm going to ask Jean Bowles to give kind of a background of the interlocal agreement, a history, and then just kind of go over the actual summary of the changes that are in this document tonight. Thank you.
Good afternoon. Glad to be here in Walton County. My name is Gene Bowles. I'm with the University of Florida, and I'm a consultant to the school board regarding school planning. We used to refer to it as school concurrency, but board planning is more correct. I want to, this is a very important process to folks that do what you do, and it may be because it's sort of under the radar, not understood, and I'd like to give you a little bit of a quick history of it, and I won't be very long, but I want to touch on why we have it and how it evolved. When the Comprehensive Planning Act was adopted in 1985, schools were specifically and intentionally left out. That's because they were a sovereign entity. And so they were not even included in the original comprehensive plan requirements and in early comprehensive plans. In the 90s, when we started to implement the comprehensive plan, and I was a planning director in Hillsborough County during those years, we realized that was a mistake. Schools have a major impact on development and are impacted by development, and coordination was critical. So around late 1990s, the state required that local governments and school boards enter into an interlocal agreement about where schools could be located and coordinating with questions of development and impact that it had in generating students. School concurrency, which is the adequate facilities part of that, was optional at that time. But following that period of time, the only county school district that implemented school concurrency was Palm Beach County. In 2005, it was the act in the state legislature was called Senate Bill 360, and it dramatically placed a great deal of emphasis on infrastructure. Not only schools, but roads and a variety of other things. It was a major legislation and modification of the what's now the Community Planning Act, and it mandated school concurrency. And school concurrency required that that process that every school district and every local government in the state have a public school facilities element that was linked together to the schools by an interlocal agreement. You are required to have it. You were required then to have it. You still are. That was an enormous project. You can imagine getting 67 school districts, 67 counties, and 410 cities to essentially do the same thing. To have uniform systems, uniform standards was an enormous undertaking. It was millions of dollars for every school district to do that, and every community. It went from about 2005 to around 2008 when these were adopted, and that's when the interlocal agreement that you're amending was originally adopted. And what that did was to essentially describe the means by which school districts were going to coordinate and cooperate with local governments and what the rules of the game would be. And the interlocal agreement was the mechanism that linked those together, and it is, and you are required to have it. Certain provisions which you must have that you have here, and then in 2011, the legislature again took up the question, but they removed the mandate for school concurrency, but retained the other elements of school planning. You still must have an interlocal agreement. So when that change was made and Walton County repealed the process that you had here, and so what we're doing is amending that agreement from 2008 to bringing it up to date to meet the current systems you have here in Walton County and also to meet state law. So what my point that I think is important is that this is an extremely important document. It's one that's been with us for some time, and what we're doing here is simply bringing it up to date and specifically addressing the question of removing school concurrency and replacing it with some tracking techniques that allow us to continue to do a good project, a good school planning process. What I would, again, yes, you should have a copy of the interlocal agreement, I assume, in your, and I don't want to spend a great deal of time on a lot of points, and just covered a few key ones here. Be happy to answer more detailed questions if you have them. As I say, a number of the changes were simply cleaning up language or bringing language references up to date in terms of where we are today and where we were essentially 10 years ago when the legislation was changed. I would call your attention to it's Section 2, the coordinating and sharing of information. This coordinating and sharing of information is a very critical part of it. With sharing population projections, school enrollment projections, information about development activity, building permit activity, and all of that. That's all a part of the process, and this sets up some of the guidelines for that. One of the key issues is sections 2.5 in the agreement, and actually 2.6 and basically 2.5 and 2.6. In effect, make it clear that anytime you are, any local government within the jurisdiction is considering a comprehensive plan amendment or a rezoning, the school board is supposed to have an opportunity to review that, provide you information regarding the ability of the school to support that capacity over time, and that is to be provided before you, for example, for the comprehensive plan amendment, that information or opportunity to be provided before you transmit that to the state. In other words, it's a required prerequisite that you get that impact analysis from the school board. Now, what you do with that analysis is part of your deliberation process. You're not absolutely required to do that, but just as you look at adequacy of roads, you would look at adequacy of schools. Is it appropriate to approve this comprehensive plan amendment or this rezoning based on the same kinds of questions you would ask of other infrastructure that you have? One of the changes that we have suggested here is that in the school concurrency process, concurrency was reviewed at the time of site plan review, the time the developer was building roads and water and sewer, and that would become a recorded plat, and you'd have a single family lot and so forth. That site plan review, or the subdivision review, and sitting beside that were site plans such as condominiums and so forth. That's the time the actual investment is being made, and that's when concurrency applied. Since concurrency is not there, we lost that piece of the information. At least it's not in the agreement, although it was coming to us in sporadically. What we've done here is to say that the school board, in addition to reviewing plan amendments and zonings, need to see the site plans and subdivision plats for tracking purposes. That's the pipeline. When a developer is there ready to build the roads and put the water and sewer in, they're serious about that development. That's going to become homes, and those homes are going to generate students usually in about a 2 to 3 year time frame. The other piece of information in which we've been very successful in getting from the county, and the local governments, is building permit information. So what the school board has with that combination of information is a good picture of what's coming down the road. And as they plan 5 years and 10 years out, they are able to see what that development pattern is looking like and how it's developing. And so what we've done is place a provision in that says the local governments will provide the school district an opportunity to see those site plans and see those subdivision plats for tracking purpose, and then we'll provide information to the county and the local governments about what the capacity information is and enrollment versus capacity. So that's probably the most significant change in this that essentially reestablished that information. You will also see in section 3.3 a citation of levels of service. 100% of permanent student stations is the level of service that the school district is meeting. You do not, meaning the local government, does not set levels of service. What you're doing here is agreeing to help them meet the level of service. And these standards are also in your comprehensive plans, but keep in mind, you don't set them. You can't set the level of service for another agency that spends the money to meet the level of service. But this is essentially the standard that we're electing to meet. So when you see a review of school capacity in your review, it will be based on the relationship of the project to this level of service that has been established here. A lot of this is procedure, and I won't try to get into a lot of that because, but let me also mention that in section 3.5.2 of the report, you will see something called the staff working group. One of the things that we've talked about and I've cautioned the community about is that this is not a committee that votes on something. This is a staff working group that convenes to share information. So it's important that it's set up correctly because it's not sunshine. If it's in sunshine, it would defeat its purpose. So they make no decisions. They simply are a means by which information is shared and so forth. And so we use language in this to be sure that they are not in a position where they would be subject to sunshine, because that would, as I say, would defeat the very purpose of the staff being able to talk to each other and share the information. So it's a nuance, but a very important one in terms of how the staff working group works and supports your work and so forth. Let me give you the last thing I want to touch on is 3.7 is the capacity enhancement agreements. In the school concurrency program, if a developer did not meet, if the capacity was not there to support a particular development, the developer had an option of entering into a proportionate share agreement, some kind of payment of contribution of land, payment of money, and so forth, to fix the problem, to mitigate the shortfall. That's not a very effective process, and of course with school concurrency that's not there. However, the concept of proportionate share is very much a part of how you look at cost of schools and relationships with development. The concept of proportionate share capacity enhancement agreements essentially allow, through a voluntary action, developments to enter into to make contributions that would enhance the school system. Typically, that's been land, sites. And that negotiation typically occurs at the planning stage, the comprehensive plan amendment stage, or in the rezoning stage, and usually for larger projects that would have enough space to provide that. The Eagles Crossing in Funiac Springs was an example of that last year, and they agreed to build into their site, that project a site. That would be, and that would be effectuated when it came about by a capacity enhancement agreement that's entered into in a voluntary agreement between the local government, the school board, and the developer. And so you see some parameters for that in the agreement. And then let me say that you'll see Section 4 talks about school siting. This agreement also gives the local government a seat at the table when the school board is looking to site schools, or to close schools, or to relocate them. So it works both ways. Essentially, the school board gets to see what's happening with development. You get to talk about what's happening with sites and the school, building of schools themselves. So let me end with that in terms of my comments. I want to just touch on a few points. Be happy to try to answer any other questions that you might have. But this agreement would bring you back into compliance with the state statutes. We think it has some very positive aspects on it, and will do a very good job in terms of the school planning for Walton County and and the school district. And it's offered to you, of course, for your approval. This agreement, of course, would be ratified by the school board, all of the local governments, and signed as a joint agreement between those agencies. So I'm happy to answer any questions you
Anybody
might
got any questions? I think we're good. You did a good job explaining it.
Thank you. Hope so.
Thank you.
No, I think you added some subtle pieces of information that I didn't quite pick up on when I read it, so I appreciate it. Thank you.
Well, it's not an easy document to read, but there is a reason why the language is there and it is used. Thank you.
Thank you. Yes. Yes. All right. We'll open up public comments. Anybody got any comments on this? Seeing none, we'll close public comments. Commissioners?
Move to approve. Second.
Motion and a second. All in favor?
Aye.
Any opposed? We're good to go. Thank y'all.
Item, oh, sorry. If you'll recall, this amendment was proposed back in November. The Board of County Commissioners directed staff to look at this particular amendment, and it came to you in January, and you referred it to workshop, which the staff did. We conducted a workshop, and that staff is here tonight to tell you about what happened at that workshop. Just in general, I'm not sure that there's a whole lot of resolution on this item, or that resolution or consensus or full buy-in can be gained. So it's just a tough issue that we have to just weigh the pros and cons of and proceed cautiously as good stewards of both the environment as well as the taxpayer contribution. So I'm going to let Jason come out and tell you a little bit about what happened at the workshop and some of the things that were brought up there that, you know, are worth talking about again.
All right, thank
Evening, Commissioners. How are you doing? Yeah, we held the workshop on February 22nd. I think we had fairly good attendance in person as well as on Zoom. Just to give it kind of a brief review, our summary of the language. Currently, the way this works is we allow to cluster density out of wetland areas. That density can be developed within the uplands of the property. if the wetlands are impacted, then there's a penalty where that density is reduced to a 1 to 20, so 1 unit per 20 acres.
That's in the current.
That's the way our current language is written. The proposal, what that would do is essentially eliminate the ability to cluster that density. You essentially would just not calculate or count that wetland area in your total density calculation. So we looked at surrounding communities, what other counties are doing with a similar issue. We looked at Okaloosa County, Bay County, and Santa Rosa County. And essentially, they also do a clustering. So the same premise where you cluster that density out of the wetland area. But there is not a penalty of a reduction of density if the wetlands are impacted. So that's the difference between what we're doing currently, what the proposed language would change it to, and then what some of the surrounding communities are doing. We received comments, as you would imagine, at the workshop, kind of all across the spectrum. Those in support of the language, those opposed to the language. We did get some comments about the general language as a whole, what we currently do, what's in our code versus the proposal, that it was unclear, and that maybe a rewrite or a rewording of some of those regulations to help it become a little more user-friendly to understand and apply. But we gave you a summary of some of the comments there. I don't know if you want me to go through and read them all, but we kind of bullet pointed some of the consensus of both kind of mindsets. I wouldn't say we came to a consensus on the language as a whole, but I think it flushed out some of the concerns that we had, some of the pros and cons of what this language would, what it would entail. And I think there's still a lot of unknown on how it would affect development if we move forward with this language. I think, developers are fairly creative people, and so I think it's a little too early to know how the proposal would actually affect. But I think at the surface it would be a significant reduction in density versus the way the current language is. So, do you have any questions?
Any questions?
I think we may have touched this last time it came before us, but what is the proportion of the land to be developed still that doesn't have like PUDs or other things against it already, so that this would affect them? I mean, it seemed to me you kind of touched that last time. Am I wrong on that, or?
Yeah, we did a very rough analysis. We're looking at like 2,663 acres, which, at our typical average density, I mean, that's about 10,000 units. But, to put that in perspective, the St. Joe project has 27,000 units in just one project. So it's not I think that's one of the things you have to weigh is, getting mired in potential legal, issues, and the amount of staff time and resources that takes away from other, really valuable projects and things that we do for the county. So there's that. I mean, it's not a huge amount of development that we're talking about, though it is, it's significant, 10,000 units, potentially, so.
And that's out of a total of, I think it was 19,000 total to when we started.
That's in your packet. It gives the figure. So we have roughly 52,000 acres, I guess, in South Walton total. The wetland acres on the National Wetlands Inventory was at around 19,000. But then if you pare that down to just the land that is available for development, there's 5,234 acres total left. And this does not include the St. Joe project because they have already got regional agreements for wetland, that it's set in stone pretty much. So, and then if you take out,
This affects a little less than half, doesn't it?
yeah, the wetlands on those parcels is around 2,571. So if you subtract that, you get, the 2,663. It's roughly about 2,500 acres that we're talking about, that would lose density or lose development potential.
And none of these look like real large tracts.
No, they're not. And so that's also something to really think about, as you look at what would be the response from the development community. Would they choose to put those wetlands on the lot because they are smaller tracts? Would it be more beneficial to create larger lots with the wetlands included in the lot? And then what does that do in terms of long-term management of the wetland area and protection of the wetland area in perpetuity if it's someone's yard? That's a real valid issue that was brought up at the workshop, because we deal with that daily when people fill their yards because people don't like wet yards. So that's something to think about.
Well, the way it's set up now, then when they cluster, these wetland portions are not in anybody's yard, so they don't have they don't legally have access to it where they would if it were part of their lot, correct?
That's right. Usually are in conservation easement or, put into common areas, and then our wetland setback, the 25-foot wetland buffer setback applies. And we recently updated the code to, really encourage that to be not included on lots. So when a property owner buys a lot, all of his lot is usable to him or her within his setback yards.
And you think that helps protect the wetlands better since it's not in their yards and they don't gradually fill them?
I mean, there are
Do something else to them.
There are two issues here. One is, do you want to limit development, and the other is the wetland preservation and protection. And our current program is highly effective, at wetland preservation and protection. It is. It may not look like that to folks when you're riding around and you see, trees coming down in wet areas, but I will, assure you that in the 5 years I've been here, we have very little wetland fill on developments, actual jurisdictional wetlands. So we do a good job at protecting those natural areas, the habitat, as well as the flood storage capacity that those wetlands provide. So, it's kind of weighing, is that issue predominant, or is, are we more concerned about the residential units that would come?
Okay. Any question? All right, thank you, ma'am. Let's see, we'll open it to public comment. Does anybody here like to speak on this subject? Yes, ma'am. And you're bringing a lot of stuff with you, so.
I know it sounds dangerous, I'm sorry. My name is Melissa, I'm gonna pull this down.
You can pull it down, yeah.
My name is Melissa Ward with Dunlap and Shipman, and let me just say that I appreciate what the staff has been tasked to do and how difficult it is, because I agree with Kristen that the language we currently have and that has developed over the years is better than what we started out with, and I'm going to show that to you. That's the majority of what I want to talk about. So what I'm about to hand out, I handed out at the workshop. Unfortunately, didn't make it into the packet. And so these are some things to consider while you're looking at what is happening, because I think there's a false narrative in the community that says, and I read it somewhere, so I don't think it's fair to, it's not speculation, somebody said it, that Walton County has, quote, for years been, quote, illegally letting developers develop at a higher density. The fact is that's not true. And what you've got in your hands is some historical documents for Walton County, because we need to know where we came from, how far we have come to see where we're going, okay? So the first thing is, and I'll just say this, most of y'all already know, I grew up here. And I don't take that as I'm better than you. I take that as I'd like y'all to know what we came from before you start dictating where we go. In 1985, Walton County had in 1975, Walton County had subdivision requirements. In those requirements, it was basically like, this is if you're in a particular area, this is the type of subdivision you'll have. They dictated to you. In 1985, they changed that to a code that had a question on how we calculate density. So what they did was, they said that you don't get, you base your calculation of density on the net, not the gross. And to do that, and there's a copy in here, and to do that, you excluded wetlands from your property. So if you had 10 acres, you excluded the 5 acres of wetlands, and you could only calculate your density on the 5 acres of uplands, which is, in fact, what I think they're trying to do today. What you need to understand, one, is that at that time, the density, and this is on the next page, was around 25 to 35 units per acre. So it technically didn't hurt anybody to drop half that property off. And I think...
You weren't able to get them in there anyway, hardly. with
No,
that kind of
gosh, no.
density.
But this was back when they had the 1985 plan. Everything in South Walton was something like resort development, or they were encouraging development to come here because they wanted people to come visit the beach, and that was a decision that they made legislatively when they adopted the language. Now, as you heard earlier under the school board thing, in 1985 there was a Growth Management Act, and then as we progressed on, if you're familiar with Walton County, things started to develop rapidly, and Walton County was kind of stepping into it lightly. So in 1991, they changed the ordinance just a little bit. They still use net density as a calculation, but they added that if you have a DEP permit, we are golden, okay? They didn't say it that way. What they said was, if you had a permit, you're considered compliant. And so that language, now in 1991, the density was a little different. But again, if you had 10 acres and you had 5 acres, you would cut out the 5 acres and calculate your density on the 5 acres of uplands. So the developer was able to, before coming to the county, would go to DEP, get a fill permit, and then come back with a fill permit for the 5 acres, for 2.5 acres of the 5 acres, whatever he could get, and then they would calculate their density. Well, that's 1991. In 1994, the community, South Walton Community Council, the people that lived here, people who grew up in Seagrove, got angry about it and asked the county to stop it and to do something about it. And part of that community, if you're in the planning realm, you know the name Andrew Duaney. If you know Seaside, you understand who he is. And part of that happened. They got together and they developed some trust documents through charrettes and numerous public meetings. And in 1994, that trust document includes a proposed conservation plan. And that language is where we get the very beginning seed of the language we have today. And as a copy in here, you'll see that I've highlighted in yellow on a 1994 plan. It mentions clustering to stay out of the wetlands. And it mentions the policy having, well, in the discussion part of it, it mentions having a give and take. Please stay out of the wetlands, you get all the density. If you're gonna attack those wetlands, we're gonna hit you with a negative. And that's the beginning of something that Walton County did, unlike anyone in the Panhandle. So when you hear Kristen talk about how much good we've done, understand that in 1994, we were already on that path. And then y'all know that in 1996, DCA came down and said, y'all have to have a comp plan. We're not taking it anymore. We're going to give it to you. But they incorporated this trust document. This trust document, a lot of the language in it is carried through today, and we've only been trying to improve on it, okay? So in 1996, the Land Development Code had some language added to it, and you see that the language in it we calculated on gross density so long as they calculate it, so long as they put it outside of it. And if they don't, if they impact those wetlands, they get a density of 1 per 20, meaning that, and back then, the interpretation was if you impacted wetlands, with the exceptions of roads, you didn't, the whole 5 acres was 1 per 20. Okay? Now that's a big deal if you got 10 acres. That's a huge incentive to tell everybody to stay out of it completely. Roads were different. So the reason that I say all that to you is that this language, it's not really about protecting wetlands, and don't let anybody tell you that that's what it is, because it can't be. It just can't be. They'll go get a DEP permit. Somebody's going to do that. And if you get one do it, then it just continues. It grows from there. This is good language that we have. It's exceptional at keeping people from doing what we don't want them to do, which is to destroy the wetlands. I've added in the packet some stuff from the American Planning Association, some quick notes. I'm not going to go over that, but I can tell you that clustering has been around since the early 1920s for this very reason. Get people out of the wetlands and the environmental areas and make it so that if you're going to get people in there, that they're on things like boardwalks and trails and they're actually enhancing the area, but not development, because otherwise they'll fill it. The best thing to do is to avoid it, not to mitigate it. Now, the next thing that I'd like to hand out to you, because there was a discussion about, and I apologize, I didn't do it all at one time. The staff just mentioned the communities adjacent, and one of them is this one is Okaloosa County, and this one's Lee County. If you're not familiar with Lee County, Tallahassee, they have some great stuff in there, and because they deal with this on the regular, they've got tons of stuff, and I know that your staff can tell you all about that. And I'm going to hand it out, but I want you to take note that they have a chart about residential densities, and in it, under wetlands, there's no bonus, there's no whatever, and it's an issue of, it's 1 per 20 for wetlands. However, it mentions that if you avoid the wetlands, you get your underlying density, or the density that's on the uplands, it's the same difference. So this was brought up to me. I was talking to a friend, she doesn't live here, and she said, well, that's not how they do it in Tallahassee. And Tallahassee has like 3 different tree ordinances. They're extremely conservative. I would like to, well, I think they are. I think there's a lot to what they do. I don't know, do you want me to hand these to them? There's going to be other people potentially here that's going to want to speak to this. I'm trying not to bog y'all down. I just want you to consider how far we've come. Walton County is beautiful, and it has so much to offer. I'm concerned that this language takes us back to the 1980s and takes us back to a time when people do things we don't want them to do. We develop language that makes it good for the developer and good for the environment and good for the community. We have parks and greenways because of some of the language we've developed today. Your staff, in just a few years ago, developed an even better language that said, if you'll please keep these preservations out of the family lots, then you're doing a better job. And they put it in there as a mechanism. We asked them to do it in the early 2000s. Now it's in your code. If we want to change this code for a reason that's relative to protecting wetlands, let's talk about what that means. But this density transfer issue is about density only. It's only about, and if you want to talk about that, that's a different conversation. It shouldn't apply to this. This is not a good method to do that. There are other ways to do it, and I think that if that's the question, you should send them back to ask for something else. I think that this should be recommended for denial. And I'm going to leave it with that. I just wanted you to understand the history here. We've come a long way.
All right, thank you.
Thank you.
Anybody else here? Yes, sir.
Hi, I'm Scott Jenkins with Jenkins Engineering. I'm just here because I'm an interested person in Walton County. We've been doing work here for about 20 years, I guess. And I actually think that there's a few things that the county's gotten really right over the past. One is the height limits here, and this other is the ability to protect wetlands through density transfer. I think it works really well the way it is now because it does give people an incentive to do exactly that. It's very rare that you could ever take all of the density from a wetland and fit it on the uplands and those kind of things, just because of all the other sort of things you have to work around, like floodplains and stormwater in the open space and all those things. So if we are talking about wetland protection, I think your current rules work pretty well. I've heard people say, what's it going to do to the development community? And in my opinion, very little. I think development community will just go away for a while, wait until the county changes it back, in a few years. But what it will affect are all those people north of 98, those families that own 10 or 20 acres who think they have a certain right and they lose it, like 70% of it just overnight. So it'll affect the smaller people more than it will the developers. That's all I wanted to say.
Thank you, sir.
Thank you.
Yes, sir.
Excuse me, my name is Randy Gardner. I'd like to speak as a developer relative to the actual impact of what we're talking about on the development world. The perception that a density transfer out of wetlands benefits the developer to double its density is very much in error. I'll give you an example, and what I'm going to give you as an example could relate to half an acre, let's say 1 acre, half wet, half. It could be 2 acres, 4 acres, 10 acres, whatever. My example is going to apply to anything you want to apply it to. And I've worked in development world in Walton County for many years. And if we've worked around exactly what we're talking about, wetlands and apartment projects, single-family residence included. Reality is, if you've got 2 acres of land that you bought, and 1 acre is wet, and the other acre is uplands. And the property, although it could be multifamily too, and we'll address that in a moment, and the property is, land use is infill, which is 8 units to the acre. 8 units to the acre is 8 units to the acre. And you can make, and the market dictates what size those lots have to be. So you can't take a piece that has allowed 8, and you could, but you're not going to sell them, and say, well, I'll go up to, if the land use allowed 8, but it's hard to get 8 and still make a marketable lot. So in this case, if you had 8 units of wetlands, you were going to transfer, 1 acre with 8 unit density, and say, I'm going to transfer it to the uplands, you won't get there. I mean, if the property already only allows 8 units to the acre, and you've got 8 in wetlands that you're going to transfer to your uplands, all of a sudden, you can't build 12, you can't build anything greater than what you already zoned for, which is 8. So the impact, I'll say the benefit from the development world of being able to transfer density is relatively limited. It only has benefit if you have large tracts of land, which we've already heard. We don't have large tracts of land. Large tracts of land where it would make some difference. But even if you go to an area in the Puny Act that may have 2 units to the acre, and you're going to transfer density, all of a sudden you got 4 units to the acre. It's not a big thing. The wetland, and I've done this also in years past, and you can apply to, obviously, for a fill permit with the DEP, and which is a process, and especially in today's world, it's not a given because you apply for the permits, you're going to get it. But that's an option. So with the bill of what we've read tonight, in my opinion, has more damage to potential preservation of wetlands than it has an impact on developers, because the impact is very minimal, as is written right now. For the reason, and to try not to be too redundant, for the reason that even though there's density transfer rights, you got no place to transfer it, because you're limited to what you can do by the existing land development code. Thank you. Any questions?
Any questions? No, thanks, sir. Yes, sir. I'm sorry, we'll get you next.
Commissioners, thank you. I just wanted to add something to my understanding of the earlier regulations. In the, I think it was like in 1992, you could transfer density from the wetlands to the uplands, but there was a restriction on the size of the lot. Had to be at least 1 acre lot. And I think, I doubt that what's going forward here right now is going to be the end result. And I think when it gets finalized, I think we're going to have something in there that limits the size of the lot. It has to be at least 1 acre, I think. So that's just a consideration.
I got a question on that. Did that have to do with the availability of sewer at the time?
It may have, I don't know. I don't know that. I don't know why it happened. I know when it happened.
I know back then there was,
Uh,
sewer was very limited in this area, and I know they dealt with that a
Septic
lot.
tanks.
Septic tanks
Yeah,
were, and
that's
it
possible.
had to have a
That's-
certain size lot for a septic tank and a well in a lot of cases. So I don't know if that had a lot to do with that particular.
Well, yeah, and I think the concept is that maybe 1 acre is not the right number, but I think there does need to be a restriction, is you can't take an area that has a large amount of wetlands, small amount of uplands, and cram in, density that gets you down to postage size lots in an area that's environmentally sensitive. Makes no sense. So I think it does seem reasonable to put some kind of a restriction on the lot size. It does.
All right.
Thank you.
Thank you. Yes, sir.
Good afternoon, Stephen Tatum. Just wanted to speak about maybe the legal standpoint of this, what it's opening the county up to. Florida has a statute called the Byrd-Harris Act. It allows a property owner who has been harmed by local government regulation, and that regulation diminished his property value, to turn around and sue the local government for the diminution in value. So if you had a property that was worth $1 million, after the regulation, it's worth $500,000, you sue them for the $500,000 difference. With the amount of property we're talking about that this would impact, you're talking about a lot of those claims coming. And even if the county settles with them, just your legal bills alone would be outrageous. Just the time taken to look at the appraisals, to go through them, decide if you want to settle, decide if you want to go to trial. And if you go to trial, you are potentially on the hook for the amount that you've lost, and in some cases, the legal fees are the other side. So I think that's something that needs to be kept in mind. We already have a system that works. It is protecting the wetlands. We have plenty of testimony about that. Postage size lots will not sell. I mean, let's just face it, market's not going to allow a postage, I don't know what that even means, but the small lots are not what we're looking at doing, any development. So I think, leave it alone and recommend denial. Thank you.
Thank you. Yes, sir.
While he's coming up, may I ask a question? Mr. Atkinson, would you concur with what that gentleman just stated?
The Byrd-Harris Act is a piece of legislation that creates a cause of action for what we consider administrative takings, basically when the government does something that inordinately burdens someone's existing use or vested rights on land, they can bring a claim against the county. They can be very costly and something we have to consider. I would venture to say that anytime you take on land use changes, zoning, and certainly policy-wide changes like this, that ultimate application of those policies could subject the county to such claims. Whether this is unique or not, I don't think it's really any more unique than anything else the county considers in terms of what it's doing. If this is something the board chooses to pass at this level, the planning board, and then something that the Board of County Commissioners chooses to pass, I think like anything that has pushback from the development community or individual landowners or persons who own pieces of property and hope to develop them but have not done so, you're going to potentially see litigation. That's a risk that's inherent in any type of land use work we do these days.
So if we deny this based on environmental concerns, we're opening the county up for major liability?
I believe what's being proposed is a change. If you vote to deny the change, nothing changes. You're in the same existing position you are now. I think what he's proposing is that if you change the rule, you're going to expose the county to a flood of lawsuits alleging Byrd-Harris takings claims.
Based on the reduction of density, is that?
I'm not going to speak for what the developers think their claims may or may not be. That seems to be the suggestion that Mr. Taylor put forward as the reduction in density. They've got to show that we have inordinately burdened an existing use or a vested right.
Or I guess he said like the value just.
So I'm guessing in this case, his argument is that there's a vested right to the density and the development rights already established, and that would be their argument. that we have now taken that vested right away. But I will say, and I know, Mr. Cosin, this is probably only the second time I've sat up here with this board. I know some of you have dealt with me in my prior service to the county. My policy is always, I don't lay out all of the county's legal positions or not. It's county legal's job, be it me or anyone else, to defend the county and its decisions. But ultimately, this is a policy question for the board, and there's always exposure with everything. We'll do our best to defend the county's actions if the county chooses to move forward with determining a policy that it feels is in the best interest of the citizens and the public.
Thank you, sir.
Yes, sir.
John King. From a practical standpoint, what we've had in the past kept the developers out of wetlands. I think everybody's in the audience or who I've heard speak is kind of confirming what what's happened for the ecology. This is much like the preservation issue. Preservation lands on a plat causes the owner, after the developer or builder has walked away. I've got subdivisions that the county required that when I developed them, I put this preservation area, and in this case on the plat, and what happens is the owners, they claim that land, they own that land, and so what you're causing, if you pass this, is you cause me to do much, much larger lots, and these people will go in and destroy wetlands that would otherwise be protected by clustering. I got a question, and this may be a staff question, is who does this apply to? When does this start? If passed, is this going to be something that if I have a development order, am I exempt from that?
I believe if you've already gone through the development process or
Okay.
you've already started, I think you'd be exempt from the new rule.
Okay. If I have a developer agreement with the county, does it apply?
I'm not sure about a developer agreement.
If I've started the process and have gone through my DEP, my core, started the design work, spent the money for the architectural, and I'm going to come to you I've already got a pre-app with all the due diligence of purchase the property. Am I going to be covered? Am I past it if I'm at a pre-app?
I don't think unless you've come to the county and started your pre-app process, I don't think you would be covered.
Well, realize there's landowners that are financially in a position they're going to sue you that have been through many of the processes before they get to a pre-app. So, people that, the current rules, developers for the most part are trying to stay out of wetlands. From a practical standpoint, here's what happens, and pardon the crude drawing, but if this is a roadway and this is an upland and this is an upland, I'm going to ask for a half acre or less to connect those two pieces of property under a nationwide permit. It's a relative simple process. It's 3 to 9 months to get done. The county's going to recognize the DEP core permit to do that. And then also, if I've got room, I'm going to cut off these corners so that I could have some lots that back up and again stay out of the wetland as much as possible. But if we go back to the old rules, what I was doing is I'm going to come in here, I'm going to make that connection, and I'm going to have a roadway, and I'm going to make these lots where they're going to eat into that wetland. Without question, that's what we were doing. We were destroying, not the developer, not the builder, but after they left, the owner was going to go in there and put their glass clippings, and then they're going to come back and they were going to have Bubba bring them a load of dirt, and then in 6 months, another load of dirt. If this is about protecting wetlands, you're going in the wrong direction. Has been said. Is this going to apply to St. Joe? Is this going to apply to the county?
I think St. Joe's already got most of their stuff done. So
Is this going to apply to the school board, or is it just going to be the landowner that's private?
The county's code broadly applies to persons coming before it. So we're not going to sit here and talk at this stage about who it applies to or not, because I don't know which of those applicants have something at pre-app, DO, or otherwise. As Chairman Perry correctly noted, If you've already got a vested DO, you're already in the process. At that stage, this isn't gonna affect your rights, is what we're talking about. So I would caution the board that I don't believe we're appropriate to talk about any specific developer or otherwise, because we don't know where they are, and I would hate to prejudice any of those developers' interest or rights if they feel we're adjudicating their issue at the same
But
time.
will it only be for privately owned property or publicly owned property? School board property, the BCC property?
The code broadly applies to all persons coming in with applications.
Okay. Will there be a vehicle in place for a variance or on a case-by-case basis? Will there be
I believe that's what we're here to talk to tonight, is how this policy is shaped. As it's structured right now, if you put in the comp plan, you're not gonna get a variance in almost any circumstance. It is all but impossible to obtain a comp plan variance at this point in time.
And it's not addressed in what we saw as far as this, what they're asking for here.
So no provision for a waiver or variance? Okay, all right, thank you.
Yes, sir.
I'm Melissa, slow on the raising the hand. Gary Shipman, Dunlap and Shipman. I just wanted to reiterate a few things that Mr. Tatum said and actually expand on that. In addition to the Burt Harris claims, and I think at a minimum what you're hearing out of the current county attorney, and I know the previous county attorney told the county commission this in a meeting, you are at least exposed, frankly, I believe substantially more than exposed to a Burt Harris claim if you do this. I believe density is established as a right on someone who owns wetlands with uplands right now. But let's just put the Burt Harris aside, because we talked about that. This ordinance, the way it's written, is only for south of the bay. And everything I've heard thus far in arguing the purpose, it has nothing to do with wetlands protection. It has nothing to do with environmental concern. It has to do with concerns about density. Applying it only to south of the bay, it would be arbitrary and capricious, and I believe a suit would get immediately filed, and I don't believe it would stand. I think it would be struck. If you want to do something like this, you can only do it if there's some eminent police power that you're trying to protect something. I've yet to hear anything about this ordinance as to what you're trying to protect. In fact, it's exactly the opposite. You pass this ordinance, you're going to endanger wetlands. You're going to cause wetlands to get filled. You're going to cause the water quality in the bay to be worse. We have things to address density right now. For example, I heard concern from someone back there about the clustering of the small postage stamp lots where if you've got wetlands and you got uplands and they move it over, well, we have compatibility analysis right now. And if you had infill, you would look at what was surrounding. And if it was surrounded by developments that were quarter-acre lots, you're not going to be able to put 16 units on it because of compatibility analysis. So you already have a mechanism to protect this. Walton County's done a real good job on this particular issue of having a carrot and a stick to protect the wetlands. I hope we don't eliminate that carrot and the stick. And frankly, at one of the previous county commission meetings I was at where they went over the litigation metrics, we spend entirely too much money in this county on lawsuits as it is. Why would we want to do something where we know it's just going to result in a bunch more lawsuits that at least one of them, in my opinion, and there's a bunch of other lawyers in this room, I think they'll probably chime in, you have a very low chance of winning.
Thank you. Okay, we're going to finish up with here before we get on the Zoom. So anybody else in the audience want to speak on this? Yes, ma'am.
Hi, my name is Tonia Nation. I'm a Walton County resident, and I'm an engineer in Walton County. I've been practicing for 21 years. And you know, one thing of those over 2,000 acres that they were talking about, if you look at that acreage in the missile overlay district that overlays over a lot of those lots, there are a lot of lots that are capped at 2 units per acre. So now you're looking at these large property owners, but they're 10 and 20 acres, so they're not really large property owners that are already capped at 2 units per acre, or in some of those are even less. So you're impacting them even further. So really, I'd like to know, like, what is the percentage of those people that are going to be impacted versus, I think this came about because you're trying to prevent those higher densities being impacted or being transferred to some of these uplands. So it's just something to consider, that there's a lot of people, primary homeowners that live here that are north of 98, that this does impact.
Thank you. Anybody? Yes, sir.
I'm David Smith, Walton County citizen, and I won't repeat a lot of what's already been said, but I think what you're going to see is increased wetland fill, and I work with various developers, and I won't say all developers are going to do this, but you will see dredge and fill permits, you'll see wetland fill, and that's a way to be able to achieve the increased density. And what we do on the front end is we do everything to the greatest extent possible to stay completely out of the wetlands, and I don't want to see the wetlands filled, personally, so I'd recommend the language stay the way it is. Thank you very much.
Sure. Anybody else in the audience want to speak on this? Yes, sir, quick.
Will not repeat what Randy Gardner, what I've already said, and heard others echo the same thing. The point I'd like to make, I haven't heard anything at the workshop. I haven't heard anything in the first meeting. I hadn't heard anything tonight of anyone that supports this proposal. The bigger question would be, why have we wasted so much resources of the county up to this point? And there's certainly no reason to continue that. The intent may have been good, but it's flawed. The impact is going to be adverse to the wetlands and very minimal to the developer. Thank you.
Yes, sir. We've got some Zoom hands up. I guess Curtis Smith. Curtis, can you hear us? Curtis, you're muted. Yeah, we can hear you now. Go ahead.
I want to give you guys a project example. I'm Curtis Smith. I'm resident in Walton County, or landowner now, and also do engineering there. And I've heard a couple engineers also come up and talk about it. So we have very intimate relationships with this very issue. We deal with it daily. But I want to give you an example of what it would do from a project that you probably remember. Just came through the process about, I don't know, 3 or 4 months ago, which was the Indian Woman Road Hawks Landing project. That particular project, we had village mixed use, maximum of 12 units an acre. We only actually got about 4 units an acre out of that when you consider the overall development. And that's because we kind of used all the upland area that we had available, other than stormwater ponds and things like that. So what you would do in this case, when we would advise a developer, is there's no longer an incentive for you to stay out of the wetlands. So there's no longer an incentive for you to use your valuable uplands for these retention ponds and other common areas that you need for the development. So because you can get more with your underlying density on the uplands you've got, go ahead and stretch it out and fill more wetlands. So there can be a negative, just like a lot of people have said, there can actually be negative consequences to this in terms of filling more wetlands.
All right, thank you, sir. Got anybody else on Zoom? Okay, well, that's it. We'll close public comments then. Commissioners, you got any questions?
Wow.
What I've heard, if it ain't broke, why try to fix it? I've heard no compelling reason to change it. Anybody's heard that? Make a motion to approve.
Can we talk a little bit?
We asked for comments.
To deny the.
Motion to approve, pass it, so let's be clear on what's before you. A motion to approve would recommend approval, so understand, I want both the board and the public to understand, whatever you do here, this still goes before the BCC. You don't,
To deny what the change.
so if you, for the policy presented, approval sends it to the BCC saying you're recommending they adopt this change. A motion to deny is a motion recommending to the BCC they deny the proposed
To
change.
deny the proposal, yes.
So you're making a recommendation to deny the
No.
proposal? Yeah, okay, I got you. All right, we have a motion, we have a second.
Second.
We have a second? No, we're not gonna discuss it. I'm not gonna ask for the vote right now. You got something you wanna say?
I'm trying to figure out, this is a complicated issue, and we can just pass the buck by saying, let the BCC worry about it. So I'm trying to figure out what is the best for the environment and what will protect the county. And I've got, in the back of my mind, I'm wondering, every time we fill in wetlands, are we opening ourselves up to another driftwood possibility?
Well, I
So-
think what they're saying is if we deny this, then we won't be filling wetlands. If we don't deny it, there's a good possibility that it will encourage wetlands to be filled in order to get their
And
maximum densities.
that's what I don't want.
Well, then you would be in favor of the
Okay.
denial.
All right.
But I'm not putting words in your mouth, I'm just saying that's what it sounds like to
I
me.
needed that help. Thank
Okay.
you.
All right, any other discussion? All right, we have a motion and a second. All in favor?
Aye.
Aye.
Opposed? All right, motion denied.
So,
Okay.
the motion passes.
With the motion to deny passes, yes, that's what I meant.
Yes, the recommendation to the BCC will be to deny the proposed change.
Yes.
Correct.
Thanks for clarifying that.
So I'm not the only one confused, okay?
I used to having them where we're voting to
Okay.
deny them, so
Okay.
it gets confusing.
Taking a break, or are you ready?
Does anybody need a break? We need a break? We can take a 10-minute break, come back. Yeah, let's take a 10-minute break. Yeah, we'll come back at 5:30, we'll be back. Oh, donuts, yeah, we need a break. I would have taken one sooner if I'd known that.
You did, man. I sent
Yeah, my brother went through it. It was like slow. 12?
like everybody's looking at me.
Larry, you doing all right these days?
leave Larry alone. Be nice to Larry.
All right, Kristen, what else we got?
Another really complicated item for you guys.
Oh, good.
So the other item that was referred to workshop, if you'll recall, from it also originated that November County Commission meeting. There were two items related to rural lands. One was kind of a reset of the lot of record status, which you recommended approval and was transmitted, and that's coming back for adoption in May. So that cleared the state, is going through the process. The other rural lands item was the ability to do 5-acre lots in large-scale ag and general ag if you had 100 feet of road frontage, and basically exempting those projects from the platting requirements. So in the administrative rule, if you're a 5-acre lot, you're exempt from the stormwater requirements. So it is possible to do those without platting, and that's what this change that you have before you would do. If you are in ag and general ag, or the other two zoning districts that we have that already have the 5-acre density assigned, you could do those lot subdivisions or lot splits without platting. And it would effectively change the density in ag and general ag, from 1 per 40 and 1 per 10 to 1 per 5 if they met the criteria for road frontage on a county maintained road.
Well, so you're saying that they could potentially get more lots, 5-acre lots out of it. They wouldn't be limited by, if you've got 80 acres and you're 1 to 40, you would have 2 parcels. They would have as much as they had 100-foot parcels on
That's
the
right.
road.
That's correct.
So that's where it changed. Okay.
Yeah.
All right.
So yeah. Private roads are not included. So when we went to the workshop, there was a lot of discussion about platting. So platting adds quite a bit of expense for anybody, looking to develop a lot. You've got to put in your infrastructure and roads and go through the DO process and the platting process. And in order to really not do that, you really kind of need to be not putting any infrastructure in. You're using existing infrastructure. You're not doing stormwater plan, all of that good stuff. So the road frontage is on a county-maintained road, so a current existing infrastructure. You couldn't come and cut them up off a private road, no. If you wanted to do that, you would need to plat.
And they would also, if this doesn't pass, then they would go through the process of platting the density they would have. Like if it was go back to the 80 acres and 1 to 40, you'd have 2 lots so you would then go do a development order for those 2 lots rather than just go through the process.
Yeah.
But there is the potential of gaining more lots depending on how much road frontage you have.
Yes, you definitely would gain more lots and less process. So.
Who's pushing this proposal?
Right.
Well, this was initiated by the county commission. They asked staff to look at this. This was one of those items that came in that November meeting. We know in our dealings that this is a constant issue we wrestle with in planning, is that people in the rural areas would like to be able to get more utilization out of their properties in terms of residential.
Just to help with that question, and it was asked earlier on the wetland density transfer. Board of County Commissioners asked staff to consider what something would look like or what a change would, how it would affect the current situations. That's when we go to work. So to say there's anybody pushing or behind it is simply direction from the Board of County Commissioners that we as staff take, and till they change the direction, we're gonna run it down the path and bring them a recommendation based on work they do, from a look around us and what others are doing, from all the information they can gather, from public workshops, which we've had on both of these matters, and then a presentation to this board for a recommendation based on all those things back to the Board of County Commissioners. So maybe that explains a little better that it's not an initiative that someone's pushing. As far as we're concerned, it's direction from the Board of County Commissioners to go look at it and bring us back some recommendations. Would that be
Yes,
accurate?
that's accurate.
Thank you, Mr. Jones.
I have another question on your report. There was a place where you talked about this would discourage urban sprawl. I don't understand that. That didn't make sense to me at all.
I don't know that I mean, so there's a couple of things that we did look at. One of the things that we looked at is Eglin's military overlay, and we're okay with the 5-acre lots in that document. So, you know, that would be one review criteria for the state, as well as the urban sprawl criteria. What you're really looking for with sprawl is to make sure that you don't preclude future infrastructure installation. So if you've got, you know, some 5-acre tracts cut up and there's some future sewer installation coming down that road, do those 5-acre tracts become in essence a barrier or disincentive to extend that sewer? So that's something that, you know, you really are always cognizant of. And, you know, I thought a lot about the 20 East corridor that Freeport is considering sewer infrastructure. So most of those lands are rural, they're not ag. Most of those lands are already rural residential, so they're not these zoning districts. And if you look kind of where we have ag spatially on the map, there's not a lot of large-scale ag, the 1 per 40, but there is a lot of the general ag, mainly north of the 20 corridor, kind of southeast of Defuniak, and then mainly north of Defuniak.
You got anything else?
No, this would be, you know, to the board and then transmitted to the state for review. So we would still get the state review, and they would be looking at the state sprawl criteria as well as the Eglin overlay.
Okay, thank you. All right, I guess anybody have any questions for staff? All right, we'll we'll open public comments. Yes, sir.
Thank you, Bruce Naylor, Naylor Realty, and appreciate all your service, and it's great to be here tonight. I'm here to speak in favor of this change. Someone who owns a real estate company in North Walton County and who's been in business for selling real estate for over 30 years. I've seen that and met and talked with families who own property in large-scale ag, for instance, or general ag, and they would love to be able to sell a 5-acre parcel, and it's been impossible. We think that we have a great opportunity with the economy, the demand for small-town America, rural America, and space that this is a great opportunity for those who own property in North Walton County who are limited right now to 1 per 40, which there's not great demand for, or may own 30 acres or 20 acres in a general ag, and they can't cut off 5 acres, that if we change this, it would give them that opportunity and we could meet that demand. You hear the 100-foot guideline, and that's the guideline, but in reality, a 5-acre parcel at 100 foot will be 2,000 feet deep. So I don't really see a lot of subdivision of 100-foot lots 2,000 foot deep. And I don't see a huge change in demand for those parcels that would meet what be more of a marketable size, maybe 300 feet on the highway by 700 feet deep, or at the most 200 feet by 1,000 foot deep. The point is, there's not going to be a huge rush to cut out 5-acre parcels, but it simply gives anyone the opportunity, and it's kind of a common sense approach to land ownership. A guy owns 100 acres. He should be able to at least sell somebody 5 acres of that property, especially today when we have demand for that type of. I'm here to encourage you to give those landowners that opportunity to do just that and sell a 5-acre parcel in general ag and large-scale ag. Questions? To someone who answers the phone every day from sellers and buyers.
Thank you, sir.
You're welcome. Thank you.
Anybody else in the audience want to speak on this? We have anybody on Zoom want to speak on? Nope. Okay, we'll close public comments. Commissioners, you got any questions?
Comments?
Comments?
Okay, sharing thoughts. Long before anyone ever heard about our beaches on the south end, 100 years ago plus, agriculture has been the #1 industry in Walton County. And it's not the #1 industry anymore, but in North Walton, it's the biggest industry. And the farmers want this to stay the way it is, and here's some of the reasons. Right now, agriculture land, and we've got some of the best agriculture land in the Panhandle, in the north end of our county. A kid that wants to get into farming out of the FFA program in Paxton High School could purchase land for about $3,500 an acre. And when it starts going to 5-acre plots, then it goes up to $10,000, $12,000, $15,000 an acre. And they're exempt from a lot of the requirements. When you start selling off the agriculture land, when you start dividing this up into 5-acre plots and everybody starts buying it for an increased price, then the kids can't. Nobody can buy agriculture land anymore because now they're paying residential rates. And we've learned on the south end from our mistakes that if we start approving things, development before the infrastructure gets there, well, we haven't learned anything. We don't have the infrastructure, the roads, or anything in the north end, because one thing Mr. Naylor was right about. If we divide this up into 5 acres, it's going to sell because Walton County's on fire. But more is not always better. And if we could just slow down the development until we can get our infrastructure to catch up with it and try and respect that the farmers, that's been their sandbox. And they've done really good for a long time. And they've got a good Future Farmers of America program at Paxton High School. Agriculture is alive and well at the north end, and this would probably be one of the first little things to start a domino effect, which could eventually, if you're going to approve 5-acre lots, well, then why not just go ahead and get into the urban sprawl? And then we've got the mess we had when we started the south end. We start getting tempted by greed, and let's just sell as much as we can for as much as we can, and don't worry about the storm drainage, and don't worry about this, and don't worry about that.
Well, you know, they can already, take my example, the 80 acres. If you've got 80 acres and it's 1 to 40, you've got the right to do 2 parcels on there anyway.
Right.
If you want to, you can make a proposal to limit it to the maximum density that they already have.
The farmers that I've spoke to respectfully requested that this be left alone and remain as is. And I've been the lone man out before, but I'm gonna go with the farmers on this, and we actually took a straw vote. We took a straw vote, and you know, the majority of the farmers said, leave it alone. Leave it alone. Let it stay the way it is. So I want to go on record as supporting our farming community, and I'm not going to support this.
Okay, all right. Any other questions?
Back to the staff, on the workshop, you know, on the other one, we at least got a list of main issues or concerns. I don't remember seeing that in this one. Was it there and I missed it?
We did have a workshop. We had maybe 6 or 7 people in attendance. It was not really well attended.
Okay.
We did have some representation from the farming community, and the issues that were brought up, I can summarize really quickly. One was incompatibility, which, you know, agricultural uses are incompatible with residential. So, you know, when you have sort of a row of houses and then an agricultural operation behind that, you can have complaints and issues on incompatibility. The land value issue that Mr. Cosin mentioned, as well as potential tax issues, which we're not sure about, because if I did look up the statute on that, if you have an ag exemption based on the statutory criteria from the property appraiser, that's really based on your use as a viable agricultural operation, that really doesn't change with the density. So I'm not sure about that one, but we did talk about the incompatibility, the potential maybe for a buffer. We do currently in the code have an ag buffer, so we kind of felt like that is there, but you know, there's potential for change to that or increase. You know, the land value question is not one that, you know, we can decide here tonight. That's, you know, that's
a market issue.
Yeah, and
Christian, would a purchaser of one of these 5-acre parcels have the opportunity to do a family lot split after the fact?
Yes, they would. And one thing to point out too about ag and general ag is that it also has the density of 1 per 2.5 currently in the code in the comp plan. If you had a lot that was less than 20 acres prior to 96, your effective density is 1 per 2.5. So that is there, and we do have the 2.5 acre lot sizes out there today as a result of that.
Before we go to a motion, I'm just going to ask the panel to please give consideration to our farmers and the agriculture community and not approve this.
Well, I think we are, but I think we've got some farmers that don't like it. I'm sure we have some that do. It sounds to me like there wasn't a lot of interest in it to begin with, or we'd had more people at the workshop. So, I mean, the fact that they didn't participate in that tells me that it may not be quite as important as to them as we thought it was.
The numbers.
Sorry, we got public comments closed so far. Sorry.
The numbers that that Ms. Shell reported aren't the same that I remember. I believe there was a little more representation than that.
You got a sign-up sheet, yeah. I don't know, I think we have to look at both sides of this issue and find out. That's why I said if you want to do a compromise, you could limit it to the density that's already allowed on that, so that it doesn't become, you expand, you know, a subdivision out there of lots on the streets. You know, if they've got 80 acres, they're allowed 2. They can do it anyway. They can go through the process of getting a development order. It just makes it easier for them to do it this way.
And one of the things
We're not limiting density, and we're not, and then that way, we wouldn't be allowing more density either. It'd be the same thing, we just make the process easier for them. Okay, sure. But I know what you're saying, and I know it's near and dear to these folks. It's their livelihoods and their lives, and they don't want them to change. But we also have to look at the other side. There are people up there that are probably not farming as much as they used to, and want to be allowed to, you know, other uses.
And that was the minority of the people that showed up at the courthouse. That's exactly what they said. And
What are you talking about? What at the courthouse? What was going on at the
Public
courthouse?
hearing.
Oh, at the community workshop?
Workshop.
I got you.
The workshop, sorry, different, not a hearing.
Well, I'm curious, aren't we supposed to make a decision based on what's presented in front of us at this meeting?
That's certainly true for quasi judicial proceedings, but to the extent, obviously, that this is a recommendation on a policy change, as a legislative item, you can consider broader policy than that.
Thank you.
So, I mean, certainly, if a board member says, I haven't heard anything at this meeting that dissuades me, and therefore I can't feel comfortable voting that way, that's within your purview. If a board member feels like, hey, I've heard from other people about this, now if that's quasi judicial, I understand that's ex parte communications, we have to have written disclosures, things of that nature, but in a legislative determination, it's really what the board feels and what the BCC will ultimately feel is in the best interest of the public and of the broad policy-making role the legislative body has.
Thank you.
Oh,
Yes, ma'am.
I wanted to mention one thing. In our research, and it has been brought to our attention, is the potential for an agricultural protection overlay of sorts that's optional, that farmers can opt into, that helps them preserve and protect their lands. There's actually a state program, and a number of states have a similar program. That's something that we could maybe tie as a companion if there's interest in doing that. You know, we can bring that forward.
You mean to the commissioners?
Mm-hmm. Yeah, you know, it's kind of an optional thing, but it does, you know, allow for agricultural preservation if that's a community interest, a little bit better than just having nothing.
I had heard some talk that the commissioners were talking about an overlay. Is that actually in the process, or no?
Not yet. I mean, it's kind of an optional program, and we would need to coordinate with the Department of Agriculture that I believe has some discussion of that I saw in my research. So, we would need to research it and bring it back. But
Optional in that it's through the state.
There's 2 different ways to do it. One is a local program, and then one is a state program.
And we don't have a local program, correct?
Right, and my memory's not good on the state program, but I did look at that, and I looked at some other states too, and basically it allows them to kind of get a little bit of a advantage in terms of protecting their lands, you know, by opting in. It's almost kind of like an easement type program. You know, so if you opt in, you're kind of eliminating that development potential or price increase that could be associated.
Mr. Atkinson, if we decided to not approve this, That doesn't mean it can't come up again in the future, right?
Just like the last issue, your decision tonight is not final in terms of the Board of County Commissioners' action, is merely a recommendation to them. So now, based on their action, certainly the board could always have it brought back up, or similar versions brought back up within their policies and procedures of bringing things back within so many months of a denial. But from the planning board, you could vote no, and as I've watched happen with planning commissions and local planning agencies many times before, you could vote yes. And whatever you vote, you could send it to the Board of County Commissioners, and they could send it right back to you for more consideration at your next meeting. So you may even see this again. So not just them. So this doesn't just go away forever if it's voted down. That'll be an ultimate call of the Board of County Commissioners. And then ultimately, if the public wishes it, they'll bring it to them to ask them to consider it.
So I guess trying to make this as simple as possible as far as how things work in my mind is, do we stand behind farmers who have been here for generations and generations, or do we stand behind developers that want to do the same thing to the north end that's been done to the south end? So I'm going to...
You also have to look at it, the farmers that want to preserve what you're talking about and own the property up there, they don't have to do this. You know, it's not a requirement, but some of them might, and this would allow an easier process to do it. They could still go get a development order and break it up into 5-acre tracts based on their allowed density. It would cost them more, so if they're going to sell to family members or somebody else, it's going to cost more to get it done, but we're not expanding, or we're not taking that away from them. They can do it. So the way I see it is, you're speaking for a group that doesn't want this to happen, for a group that might want it to happen. So they're asking their will to be done on people that they don't own their property. So, because they don't have to do it. But it's also something they can do, because we're not taking that away from them. They can do this anyway. Whether we pass this or not, they can still go through the development order process and get it done. It's just going to cost them more.
We're not going to agree on this, but we will walk out of here friends like we do after every meeting.
It's just a discussion
Okay,
too. I'm just,
okay.
I'm looking at both sides, trying to figure out,
Yes, sir.
Well, if I'm a farmer and I don't want 5-acre tracts and this passes, I would likely have my property surveyed out into 5-acre tracts, have it appraised, put a conservation easement along the road frontage, and get a tax benefit out of it. So, I mean, there's may not be as detrimental to landowners as
This was such a tough decision, and it was hard, and it was complicated. So this is what it came down to. There was about, and this is just from memory, there was about a dozen farmers there. And it got to the point to where I said, just give me a show of hands. How many people want this left alone? And about 8 farmers raised their hand. And the other 4 farmers raised their hand based on what you just said. They wanted to do what you just said. And, it was complicated, it was hard, and I just did the American way, and I just went with majority rule. And that's how I made my decision, and it was, right, wrong, or indifferent, the majority of the farmers that were there on that night at that workshop in the courthouse, the majority of them, 8, said, please leave it alone. So that's all I can say on the subject, and we can go ahead and vote.
Well, we don't have a motion yet. So we got to have a motion first. All right, commissioners, what are your wishes?
I'll move to approve.
Could we add that we don't allow them to expand density? Is that acceptable?
We can make a recommendation for that, can we?
Recommendation? Or is
That
that
it
a
doesn't
reasonable
increase the
thing?
allowable density on that
I don't know.
property.
Is this a reasonable recommendation or not?
Yes, I mean, you could say that you're just exempting from the platting requirements, these 5-acre lots with 100 feet of frontage, and that they still meet the current density. That's an option.
Yeah, okay.
To cut down the number of growing septic tanks that just keep finding its way to the Florida aquifer, can we also put in a requirement that they have supporting infrastructure, sewage, water, and everything that they're supposed to have for a planned community, and not continue doing what we did down south? Is that a possibility?
I don't think you're gonna have sewer
Okay.
up these
out
roads.
there.
Okay.
It doesn't
Yeah, it's
even
not
come
out
there.
there.
All right.
And there's a requirement for minimum density or minimum size lots for those already anyway so. Okay, make sure I got the motion. Did you make the motion?
Made the motion to approve, correct.
Did you add her addendum or whatever?
Is that a reasonable thing to you or not?
I don't,
You don't want,
I don't want to do that.
okay.
Okay, we have a motion. Did we get a second? We have a motion and a second. All in favor?
Aye.
All opposed?
I'm going with aye.
Okay. All opposed?
No surprise here. Opposed?
Motion carries. All right. All right, we got something else? Feels like we've been here all day.
Congratulations.
9:30 yet, so.
I know.
Ready, Mr. Chair?
Yes, sir, go right ahead.
This is a request to approve by ordinance rezoning 21-000001. It's being reviewed by myself, Bob Baronti. This is a rezoning application submitted by Tonia Nation on behalf of Philip Krupp, requesting to change the current zoning district from conservation residential 1 unit to 2.5 acres to conservation residential 2 to 1 on approximately 20 acres. And the parcel number is identified in your staff report. Mr. Chair, this application request initially started with a future land use with a higher density in the zoning portion of the rezoning request portion of it. It was going to run in issues with the missile training corridor. We spoke to the agent and the applicant. We explained to them the issues and the problems addressed. They agreed to withdraw that application and move forward with a zoning request that would meet the Air Force's requirements and the county's requirements in the corridor. They came back with as I said, a rezoning, so they're going to leave conservation residential alone. They're not going to try to move in residential, and they're just going to simply do the conservation residential 2 units per acre that would be okay with the Air Force. The Air Force re-reviewed it and sent an email. It's in your packet saying they concur and support this. It meets the Land Development Code and the LDC. There are no outstanding comments. There's been no public comments received as of last time I was at my desk. The applicant is here to speak in depth. If you have any questions, can I enter the staff report in the record?
Yes, sir, thank you.
And do you have anything for me before I sit down and turn it over to Ms. Nation?
Any questions for staff? No, sir, you're good.
Thank you.
So I am Tonia Nation with AvCon. I am the agent for the project and the engineer. Originally we were looking at 4 units an acre, but after the military missile overlay district comment, we did reduce it to 2 units per acre. And with conservation residential, 2 units per acre, there is a 60% preservation/conservation requirement for open space. So the plan that we have put together, it is conceptual, but that plan does account for greater than 60% open space. And the intention would be to preserve that and to, when you actually look at the right-of-ways, backyard, side yards, it would be well over that 61% that we even have in the plan that's in your packet. And there is a lot of, if you look at the region, which is in the compatibility analysis, but if you look at the region, there are a lot of higher density parcels within this general vicinity. There's a lot of 4 units per acre. There was some village mixed use that was recently approved about a year ago. So but within this general area, this is very compatible with that surrounding use.
Okay.
Questions? The total units would be 39 units. I do have it's a little, just a plan that shows where this is conceptual. This would have to go before, for a development order, but this is the wetland areas. This has the buffers. We provided buffers around the mosquito ditches as well. So we have 25-foot buffers on either side. So we have buffers along the roadway as well. So we have a lot of buffering in here, and you know, whoever they may ultimately decide to do something different. They may go with but this was just maximizing the density at 39 units per acre. This is 19.56 acres.
Any other questions? Thank you, ma'am. We'll open up public comments. Anybody want to speak on this? Yes, ma'am.
My name is Mandy Cooper. I live at 1075 East Nursery Road, which is just right around the corner from this proposed development. First, I want to say you are very smart, Kristen. Like, I want to hang out with her. She's so spot on. Anyway, I have a few problems and concerns with this property. Let me just kind of put my glasses on and tell you a little bit about it. I've actually been around to several neighbors who vehemently oppose of this. And the main reason they're doing this and why this is all conceptual is because they just want to sell the parcel. What I'm hearing and what he pointed out is that what the south end of the bay has done is overpopulated. You know, the wetland issue, I think what they're trying to do is to cut back on the density. We cut back on the density, then maybe let's don't rezone all these parcels. You know, they were zoned this way for a reason, you know, for conservation residential. And honestly, on that street, there are several 10 and 20 acre parcels. You all probably drove by the corner, I'm sure this probably came before you, but the corner of Nellie and Chat Holly, where those 40 acres were just, I swear I can't even drive by it. It makes me want to cry. But anyway, I'm getting on a tangent. So let me just say a couple of reasons why we do not want this to pass. Our primary concerns are a decrease in protection from flood and wind damage, damage to vital wetlands near the Choctawhatchee Bay, damaging impact to critical habitat, biodiversity, and wildlife, increase to traffic to roads with no sidewalks, increase to traffic during mandatory evacuation given our flood zone 331 is going to be a parking lot. It already is. And infrastructure, which is unable to keep up with the amount of development. And I'm hearing this over and over, the infrastructure, we don't have it. I mean, I've lived here 20 years, and I've seen a big, big change. I sell real estate for a living. I mean, I sell these houses, so I want there to be houses, but the zoning is there for a reason. And rezoning this one, and then also there's been that property is under contract. It was listed for $1.79 million. Property appraiser site has it for $175,333. That's what they have the value on there. In his listing, he says, a rare prime 20-acre parcel for residential development in the booming South Walton, Santa Rosa Beach area, which is one of the highest growth districts in the county. And Walton County is one of the highest growth markets in the state, as well as the Southeast. A rezoning process is in the works to conservation residential CR21 with a total of 2 units per acre for approximately 20 acres. Expected completion of rezoning is April 2021. Agreements are in place for the adjacent 20 acres to the east, which are also available. Call agent for details. Now, that was removed after the last meeting because I brought that up. That comment's not out there anymore. But obviously, the thought is there, and there are other larger tract owners that are thinking, well, shoot, I mean, if I can get $1.8 million, I might as well go through this whole process too. And then a big thing for me is the wildlife. Where are they gonna go? I mean, I know there's 50,000 acres of conservation in Walton County, but are they gonna cross 98 to get there? I mean, they're gonna swim the bay to get out of all this? I mean, we've got to stop somewhere. Also, since that one went under contract, that same agent has another 2 listings that came on yesterday on the same road. Let me read those real quick. Property is zoned CR1. This is in the agent notes. This is not public comments. Property is zoned CR1, 1 unit per 2.5 acres, but is prime for a zoning change to a minimum of CR2 of 2 units per acre and is priced accordingly. A higher density is possible due to the adjacent development directly to the south by D.R. Horton of 170 units on 30 acres. The property has several dwellings which are currently occupied by a family member who will move upon notice prior to closing. Contact listing agent, blah, 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 for viewing instructions. Wetlands delineated, whatever. As you can see, this looks like a domino effect to me. I mean, one guy's gonna make that, then somebody else is gonna wanna do it. And that's what's happened already on the corner of Nellie and Chat Holly. That's why I'm here. I'm a mom of 2. I work full time. I don't have time for this. But at some point, like I said, I've been here 20 years. Somebody's gotta do something. And I reckon it's gonna be me. Anyway, I already said that about the wildlife, but I think that's all. I hope that you'll require the developer to stay within the present zoning, which is 1 house per every 2.5 acres. Thank you.
Thank you.
Ma'am, so you want this to stay as is? Okay.
Yes.
And not to be approved?
Correct.
Okay, yes, ma'am.
I live at 21 Joy Lane. I'm sorry. So I just want to thank you. You guys, it's unbelievable, the decisions you have to make. I appreciate all you have to wait for the county. I am also opposing it. I'd like to take a minute to go through the report. On page 3, it says, the reason for the requested change is to add density for a single-family subdivision because this density is not allowable under the current rezoning district and would require a change in order to have the density. I don't see as more density as legitimate justification for changing zoning. What it would do is it would clearly make it more profitable for the property owner, but where is the public benefit to changing that zoning? I mean, they purchased the property knowing what the zoning was. They purchased it for a certain amount. I know they want to sell it for more. I get that. But just do it with what the zoning that's required. Page 5 states that there is a 60% open requirement for open space requirement. But under page 6, they say that this property is, on page 6, number 5, commercial development does not require a recreational component. But this is a residential. Anyway, so I just think that needs to be cleared up, just so there's no mistake. This is not a commercial property, it's residential, but it's part of the report, it seems to me, unless I'm misunderstanding it. Also, in number 5, they talk about transportation states that is accessed from Forest Shore Drive. I don't know where Forest Shore Drive is, but it's not off Nellie. I just think these things are just inconsistencies that probably need to be cleaned up. No, on page 7, the environmental review, on number 4, calls it conservation residential to low density. And I understand it was a low density at the beginning, so that probably just needs to be changed.
You may be referring,
Right, so, but that is what's in the report right now, so that probably just needs to be cleaned up. On page 8, the floodplain analysis, seems to me that that's accurate. It says, proposed amendments to the future land use map that increase the density of development allowed in the floodplains are discouraged. That's simple. If you look at, and you probably have a larger of this, but this is the proposal that they're proposing for that area. This is their wetland overlay. So if you do the overlay, one of the streets is coming straight through the wetlands. So there's no way you can't impact the wetlands with what you've got. Yeah, I'm not an engineer, so.
There is a small wetland crossing.
Right. So anyway, I just don't see any benefit to rezoning. There's no public benefit here. I don't see any justification for it. We already experienced a lot of flooding in our area. You know, I'm sure these developments will be required to have a detention pond or retention pond. Both of those need to be maintained. They're not as beneficial as a natural wetland area would be. I'm concerned about the wildlife corridor. There's a lot of wildlife through there where the Atlanta Flyway and Mississippi Flyway come right through this. This is the perfect stopping point for birds as they fly through. And I understand most of the good parcels in our county have been developed, and so now we're looking at parcels that have some wetlands on them, which, you know, are beautiful. Let's just not change the zoning on them, unless we're going to have the same problems that we have for the, with the density transfer issues that we were talking about earlier. And actually, I was speaking to somebody today who is wanting to move from the 30A area, and he said, but I hear you guys are having a lot of rezoning in your area. Because we do have a couple that are coming up, and there is some concern that we're going to have the same density issues. And as Mandy said, you know, when there's an evacuation, 331 is already backed up. I know our house, when we get a lot of rain, you know, we can become an island. And the more we develop, the more impervious surfaces we have, the more flooding we're going to have. And, you know, as she said about Nellie and now, and you used Nellie and Chat Holly as an example because that is village mixed use. It is, which has just changed, but everything else around there is conservation residential, one house per 2.5 acres if you look at the map south, north. So you've got that one development, and then you've got a couple of mosaic oaks. But we can't have everything in that area.
These are, if you look at the map, it does show that there's a variety of zonings within this area, and we are intending to stay within the conservation residential.
What's the zoning for a small neighborhood? I mean, what's the density, Kristen?
It is 4 units per acre. And those were approved.
But right now, it's 1 unit per 2.5 acres.
Not on the ones I'm asking about. I'm asking about the neighborhoods that are already zoned for the surrounding properties to the south.
Yes, sir. They are 4 units per acre.
And
How many, 8 units per acre? Okay. I was just trying to figure out what does.
But if you look, you know, I just think it's not compatible. It's not consistent with the neighboring properties. You do have a few, and you had that Horton development that just came in through, you know, and they've clear cut the whole area. And you do have 2 other developments, but most of them, and I know that there's some other people who want to speak, but most of them are conservation residential. Is that right? Oh, okay. Well, anyway, let me see.
You're asking what the surrounding properties are?
I know what they are. I have a little map. Let me just find it in my notes. They are conservation residential, 1 unit per 2.5 acres. And let's just stick with that instead of having problems and
That's why I was
rezoning.
asking what the property to the south was, and I think there's some stuff to the northeast that's different.
Yes, there's a iPad right there that shows, I don't know if it's showing in front of you, that shows the future land, the zoning, current zoning for the parcel and
Right,
the
this
parcels to the north, south, east, and west.
So, but you've got most of the area around there is conservation residential, 1 per 2.5 acres. So to be consistent with the neighborhood, I mean, unfortunately, I think that Horton development got pushed through. Not a lot of us knew about it. I knew nothing about zoning issues, quite frankly, until Chad Holly and Nellie, and I drove by, and every tree was cut down. We have a couple of neighbors who are having flooding issues because of developments that have, you know, our area is green for a reason. They don't decide on zoning issues or restrictions or whatever capriciously. You know, this is thoughtfully done. We can't just change it. If we start changing it, it's going to be the domino effect. I mean, there's so many pieces of property right there that want to be sold, and they want to be sold for a lot because of the density ability, so.
Thank you, ma'am. Well, I got somebody back here too. I'll get the people in the audience first. Yes, sir.
Fred Tricker, Tricker, and I just wanted to build on what previous speaker was talking about in terms of public benefit. Staff report says that this application meets the land development code, the comprehensive plan. Well, it really doesn't. It doesn't meet it at all, because they're asking for a zoning change. They want to change the zoning map, which is part of the land development code. And I understand that the applicant is doing it for financial benefit, but the county is under absolutely no obligation whatsoever to give them a zoning change. And I think in terms of what the previous speaker said, increasing density is not an appropriate justification. I don't know how that benefits the public. And I have to believe that if you give it on this property, you're going to give it on all the other properties around there, potentially, and the cumulative effect is going to be disastrous in terms of traffic, in terms of floodwaters, in terms of all those considerations. And, you know, you said when we were talking about the wetland density transfer thing that we didn't understand why we were doing it. Well, this is why. It's because of proposals like this. And you may have missed it. It's not just increasing the density. By the way, in order for you to make an informed decision, you need to know the impact of what this proposal is all about. And so if you look, and this is not in the staff report, and I think it should be, but I'll give you some numbers. Right now, as it currently sits, without the density transfer, they're entitled to put 3 homes on the property because of the wetland restrictions. And if you give them the density transfer, it goes up to 7. 7 on the upland portion is maybe not that bad, but there's also a conservation requirement of 80%. Not 60% on conservation residential 1 to 2.5. Well, I wish it had been in the staff report. It's something that should be highlighted. People need to know what this is all about, but you're basically going from 2 units per 5 acres to 10 units per 5 acres. You're increasing the density on that parcel of land by a factor of 5. You're going from 7 to 39. And that is, to my way of thinking, is totally inappropriate. And you may have missed something when the engineer spoke about open space. And because of the density transfer thing, the open space requirement, the way they do that in Walton County, which I don't understand, you also transfer the conservation requirement. In other words, they can take the upland portion of the property and they can clear cut it. They don't have to preserve anything. So they went from 80% preservation requirement down to 0. And this is in an area it's in a floodplain. They haven't even determined what the base flood elevation is. It's a flood zone A, which a high hazard area. And with the wetlands there, I just don't see why Walton County would want to grant this kind of a zoning change. It's wrong, and there's no benefit. In fact, there's a lot of costs associated with it down the road. If you want to change the zoning, you got to do a study on the entire area and take a look and see what kind of density that area will really support. Because when those zonings were established, that was based on I'm assuming it was based on conservation requirements because of the wetlands, because of the flooding. And they did it for a reason. And you can't just change one little parcel without looking at the whole thing to see what the real impact is and what the cost is to the county of increasing density. It's just not right. So that's all I've got. Thank you.
Thank you. Kristen, that brings up a good question. Why was the original zoning land use put at conservation?
From all that I could tell from researching it, it was based on environmental considerations. So you have areas with floodplain and wetland concentrations, and that plays out if you look at the map and you look at the analysis that those areas are. There's some that aren't, because they had imperfect information, but for the most part, they are low-lying, wet, environmentally sensitive areas.
Okay, thank you. Any other questions? Oh, I'm sorry, we got other people on public comments. Anybody else in the audience? Yes, sir.
My name is Mike Saylor, S-A-Y-L-O-R. I'm a resident at 881 Nellie Drive. We own 10 acres on that quiet street, which is Nellie. And the majority of the lots there are 10 acres. There's a few that are subdivided in smaller amounts. But we're okay with the current zoning. We're not against development. We're just against the rezoning as proposed. And I have a petition here signed by 67 people, most of them on Nellie Drive, but some of them in the surrounding streets. So I'd like to present this to the board. Who should I give this to? You?
He's behind you. Sure, pass it around.
So based on the low density there's not many people really live on Nellie Drive right now. I don't know the exact number, but it's a very small number. We have the new development that's been mentioned, the D.R. Horton, that is coming soon. But it's relatively a quiet rural area, and this is not compatible to the intent of this area. And that's why we live there. We played by the rules. We built according to the current zoning, and we expect that others should do the same. So any questions for me?
You said you live on Nellie Drive?
Yes, sir, 881.
Okay, that's all I was gonna, it looks like there's one house to the north of this property.
We did a lot split with our son, a family split. So he's at 845 and we're on 881.
Is he right next to this property?
We're close. We're probably a quarter of a mile from this proposed.
Yeah, I was just looking at the aerial and it shows, it looks like there's one house to the north of this property.
Haven House owns that property?
Yes, sir, yes.
Okay,
Yes,
is that for group?
I believe it's group living.
Okay, all right. How many people live there? Does anybody know? 40 people? I got you. Okay, thank you. Appreciate it. Anybody else in the audience want to speak on this? Yes, come on.
Mandy Cooper again. Correct me if I'm wrong, when they're trying to do a variance, you're supposed to notify the neighbors within 300 feet, is that right?
Yes.
Yes, is it 300 feet? So I'm looking at there are a few parcels that were rezoned, but you think about it, if you're looking at 10, 20, 30 acre parcels, 300 feet might be 3 or 4 neighbors. So unless, so I'm just saying as the neighborhood didn't realize that that those were even happening until it was too late. We didn't realize. That's why we're paying so much attention now, and I'm sorry. But it's I was just going to say that's why there are a few that have higher density in theirs, because we weren't paying attention because we didn't know until it's too late.
Okay, thank you. All right, nobody else in the audience, so we've got a Zoom. M. Bailey.
Can you hear me?
Yes, ma'am. Go right ahead.
This is Melissa Bailey. I live on 150 Cessna Street. I've lived here for 27 years. I want to bring up and reiterate some of the things that some of the other speakers have said. One thing is I would like to connect with them because we need to stop all this rampant development that we have going on. And because you only notify people within 300 feet of a development, we're not getting the type of notices that we need. So we need to change that type of setting so that a larger area is notified when somebody wants to come in. Had we known about this development there at Chat Holly and Nellie, the Kirkendall farm, I don't think that it would have gone through. Chat Holly has now become a mini 98. I personally walk in this area daily. I have seen people, children, dogs, almost get run over on Nellie because people are racing through there at like 60 miles an hour. And I oppose this rezoning, and y'all need to take note that you are selling our souls for money when the zoning is in place for a reason, and this needs to stop. Thank you.
Thank you. Anybody else on Zoom? There's nobody else on Zoom, I guess. Okay, we'll shut down public comments. Well, we have a Jacqueline. Yes, okay. Jacqueline, are you there? You're muted. There you go.
So sorry. Yes, Jacqueline Alwyn, and I own property on Harvest. I've got 20 acres there. And I know everyone has been speaking that this isn't consistent with what's being developed there or is there now. But in that area right now, there's 2 small neighborhood developments and also low density. And then across from us at Harvest, there's a Seclusion Bay, which is also a small neighborhood. So, and you also have Mosaic Oaks, again, which is another smaller neighborhood. So there is and has been allowed this kind of development in this area, and there continues to be. So I kind of disagree that this is not consistent with the area and where it's going. And I therefore feel that this should go through.
You said you feel like it should or should not?
Should. I do think it should. I think it's inconsistent with the other properties that you have approved in that area.
Okay. All right, thank you. Did we have anybody else on Zoom? Okay, well, we'll close it to public comments. Ms. Nation, would you like to comment on any of the things that were said?
Yes, sir, I would. One of the comments was that we would not be required to have conservation or open space, and this does require 60%, and the intention is to, of course, comply fully with the code and have that 60% or more. And of that, 55% of this property is in wetlands, and the plan is to preserve those wetlands in its entirety and provide additional buffering to ensure that we have adequate wetland buffering, and those buffers would be outside of the lots to ensure that those buffers are preserved and maintained in accordance with the current, in accordance with current requirements. And then this is not the same type of clustering that you're seeing with the D.R. Horton subdivision. This is going to be more of a small neighborhood with buffering around the parcel. So this will be more consistent than what you would see on a parcel that is developed that was zoned mixed use. This will be in tune with the conservation residential requirements.
Okay, thank you, ma'am. Kristen, I want to ask you again, that parcel to the south, this small neighborhood, what building on it?
Oh, you mean the existing density, not the allowable?
Well, I wanted to know what the allowable density was, but what is it? Because that's one of those houses they've got a bunch of people in?
Oh, yeah, I believe it's
Haven House?
some kind of rehabilitation. Yeah.
Okay. But otherwise, it's zoned small neighborhood, and that's 8 to the acre?
Up to 8, 4 up to 8, yeah,
4 to
depending
8.
on your design criteria. Yeah.
All right, thank you, ma'am. Anybody got any questions?
Discussion? Okay. So where's the biggest density problem in our county?
Probably depends on who you ask.
I'm just going to take a wild guess. It's the south end.
Oh, yeah, I thought you meant in the south end, which part would be the worst?
No. So I'm not trying to make light of this, but it almost seems like it's a game of how many sardines can you put in the sardine can? And the sardine can's already full, and it's been full, and we don't have the infrastructure to support what we've got right now. We've got gridlock traffic. Hopefully the mobility plan will take care of a lot of this. The neighbors don't want it. We just keep compounding the problem with development that's fueled by greed. And I'm sorry, I'm a hardcore environmentalist, and I can't go along with that. So once again tonight, I'm not going to be surprised if I'm the long man out, but I'm used to it.
Yeah, you can make a motion if you want to.
I make a motion that we don't approve this.
Motion to deny? Okay, we have a motion. We have a second?
Second.
Motion and a second. Any further discussion? All right, all in favor?
Aye.
Any opposed?
Wow. Wow.
You can go home now, can't you?
Oh, man.
If I may, real quick, Mandy, and for those of you who express concern over not knowing what's going on the Walton County Planning website, they have an interactive map of all the projects. It's very good. And if you just set a 30-day auto reminder to look at it every 30 days, you might. Yeah. Good. Okay. Hey, great job. Yeah, it's fantastic.
The planning office gave us some really good advice, so we appreciate the direction.
Okay, we got anything else? I think we do, don't we?
Yes.
Can we have a discussion, since we're under the sunshine law? And
Well,
can't
we have
ever-
quasi judicial items still, Mr.
Yeah,
Chairman.
we got more.
Yeah,
Okay,
another item.
okay, I thought we were finished.
Yeah. We are doing the quasi, yes, one item.
We just
So-
have one item left?
Yes.
Okay, one item.
So
Okay.
8 and 10 were continued, correct?
Correct.
Okay, I'll go ahead and swear everybody in at this time. Not sure it's strictly necessary, but it's quasi judicial. We'll do it for a public hearing. Anybody wishing to speak on item 9, which is 21-0536, the Windswept Estates Phase 6. It is request for approval. Final order. Please stand, raise your right hand. I, please state your name.
Aye. Kristen Cho.
Do hereby swear or affirm that the testimony I present will be the truth, the whole truth, and nothing but the truth. Thank you. And Commissioners, I'll note that under quasi judicial, we had a question at one of the last board meetings. So I feel like I probably need to do this, not specifically on this item, but for the board's edification. The Walton County Code of Ordinances requires that if you've received communications from any person, group of people or otherwise, about an item that is going to appear before you as a quasi judicial item, you're required to disclose the substance of that, who sent it to you, things of that nature. I can go over every item that has to be included in that in writing prior to the commencement of these public hearings. The question was asked at the last board meeting, because I believe in the past the attorney has asked, does anybody have any quasi-judicial ex parte disclosures to make? It's not something I'm going to do. My reading of both the ordinance, and the reason we have that ordinance is a specific Florida statute, is that the ordinance protects the board from having those ex parte communications be deemed prejudicial to the process. But for that to work under the statute, we have to strictly comply with the terms. And that is, they must be made at or before the hearing so as to allow those who have an alternative opinion to offer their objection. So if I ask you now at this hearing, do you have an ex parte communication, and you say, sure, but you haven't done it in writing, one, you've not complied with the ordinance. Two, really difficult for somebody to respond. So I'm just going to remind you, as I will the other boards that here at quasi-judicial, that to comply with the ordinance, you need to turn in those communications in writing in advance. And what we'll be doing moving forward is having staff provide that as part of the record so that it can be made part of the record prior to the start of this process. Now, if you feel like you need to disclose it, hey, I messed up, I'm going to leave that on you. But if I ask you that question, I'm putting you on the spot. And if you messed up, then we just need to discuss that or address it elsewhere. But otherwise, you do need to submit it in writing, and the verbal disclosure here would likely not provide us the protection. Not that we've had this issue come up, we haven't been challenged on that point, but after reviewing the code and the statute, that's not something you're going to hear me ask during quasi-judicial proceedings. I'm going to leave it on the board members to understand their obligation, get that turned in, and then we'll put it on our staff to get it made part of the record in part of the packet early enough so that these, and we don't have much public left right now, have a chance to see that and comment on it. So just as a general comment about how we're going to handle those, that's going to be my recommendation moving forward. Yes, sir, Mr. Coase.
Okay, so if I'm trying to educate myself and I go to a public workshop and I'm trying to learn about an issue that's coming up, is that something that I need to report to you?
I cannot imagine what public workshop you would be attending that would directly relate to a quasi-judicial item.
Okay, so like when I went to the workshop about the farmers on the...
That's a legislative item. It will be if it's about a specific project that comes up under quasi-judicial. So if you go to such a workshop, let's say you do, and then you get your agenda, you look at that language there, it says quasi-judicial items right there above number 8. If you see that, then yes, we'll need you to make a written disclosure of the information you received. The difference with quasi-judicial is there must be competent substantial evidence. It has the hallmarks of a legal proceeding. It is, by definition, quasi, somewhat judicial.
All right.
So only if it's going to appear under the quasi-judicial, that's when we'll need you to make those written disclosures. For the board, if any one of you has a concern that you think you may have received or become subject to an ex parte communication, reach out to staff. Matt, Kristen, Mr. Hall is there on Zoom. I see him nodding, waving at you there. He's staff's counsel, so certainly he's always right here if you want to come by. And don't hesitate to call me. We're going to make sure you stay out of trouble. But I also want to clean up the process to the extent that I believe at times the question's not been, has there been any written ex parte disclosure, but are there any? Two different questions. Want to try to make sure we're doing things correctly and also not subjecting our volunteers like you to unnecessary exposure. So just as a broad comment.
So sometimes the developers have meetings on the quasi-judicial items. So that would be something, right? If you attended, I don't know if your advice would be to not attend those, or, if you're on
My advice is if you know it's a quasi-judicial proceeding and you know it's coming before you as a quasi-judicial proceeding, don't attend those meetings. You need to hear it here in this meeting so that every board member is hearing the same information and you're making the same decisions on the same set of facts. That is fair both to the applicant, to those supporting the applicant, and those opposing the applicant.
Thank you. Thank you. Yeah. Ready?
Yes, ma'am.
So our final item is the windswept Phase 6 development. This is 78 lots, single-family subdivision on 58.4 acres. And it leaves 3.93 for possible future development. It was reviewed by Renee Bradley. It's been through our technical review committee, and you can see in the staff report the findings from that committee. And I'd like to enter the staff report as well as all development plans submitted to you within your packet into the record.
Okay, thank
This is adjacent to the existing windswept. Now I'm going to let the applicant answer any questions you may have or make a presentation if you wish.
you. Okay, thank you.
Good evening. My name is Tracy Jerningham with JP Engineering. I'm certainly glad you saved the easiest one for the last since we don't have much opposition here tonight. But what we have has been before you 2 or 3 times already through the large-scale amendment process and the developers agreement. So now we're at the stage with the development order application. So we're meeting all the requirements of the land development code. You pretty much know the nuts and bolts, I think, of what the development is. Phase 6, the final phase of the overall windswept master plan. Like I said, we do meet all the land development codes. There have been some questions on the stormwater and the things that we typically meet, but I do want to just touch on those that may answer some questions before they even have to be asked. We do meet the stormwater requirement, the 25-year attenuation. The original plans for Phase 6 had the stormwater drainage actually discharging into the golf course. We are retaining all of our stormwater within our site, so we're not discharging anything to the golf course. So that's helping not only the drainage of the golf course, but we're attenuating that required event as well. And as well as the 100-year event routing. So we can route at least the 100-year event without having any breaches or stormwater issues on site. We had been coordinating with the existing windswept HOA, the developers agreement that you approved on the last meeting. That's still the intent, is to have that developers agreement approved at the May BCC meeting. We do still have some minimal development around the public well site, and we've worked closely with the city of Freeport. The county does have a requirement of a 200-foot exclusion zone around that public water system. We have a letter of approval from the city of Freeport that we've worked with them, Dewberry, city manager, and the mayor, about taking that development and making sure that all homes and all septic tanks were outside of that 200-foot. Now, minimal development means they can put a fence, or I'm sorry, they can clear it, make a yard out of it. There can be a pedestrian path that connects the southern half to the northern half where the amenity would be, the future amenity parcel. So just very minimal development, but no septic tanks, no homes within that 200-foot zone of exclusion. Density is fairly low. We're not applying for the max density. The developer agreement limits that to 80 units total. We do have a small parcel on the very southern tip of that's undeveloped. There's a wetland crossing there and some uplands, and that's just something that the owner wants to deal with on a different day. So if you have any questions, I'd be happy to answer.
Any questions for the applicant? Okay, we got you. Thanks. I guess we'll open it to public comments. Waited everybody out. Does anybody on Zoom want to speak on this? Seeing none, we'll close public comments. And commissioners? We have a motion?
I'll second it.
We have a second. Any further discussion? All in favor?
Aye.
Aye. Any opposed? Motion carries. Is that it, Kristen?
Okay.
Okay. Oh, you had a comment you wanted to make, Mr. Coase?
Since we don't ever get to talk,
Yes, sir. Go ahead.
since we don't ever get to talk, this is our only opportunity for me to run ideas by you and see what you think. Okay. So tell me if this is, would be a good proposal, and if maybe there's a possibility we could get some traction with it. Okay. 6 years ago, when my wife and I were restoring a home and renovating it, we put solar panels on our roof. And since we put them on, we haven't paid 1 penny in electricity. And to me, that's the only way to go. Now, I am not for solar farms, especially the one in the north end where they used our grade A agriculture land to put their solar farms, their solar facilities. Because the 99% of that electricity wasn't even benefiting Florida, much less Walton County. It was going to Alabama. There was really nothing in it for us. And when I say us, I mean Walton County. But I'm not against solar. I'm a very big supporter of solar. But it's got its place, and it's on our roofs. Now, there's no way I would ever even think about recommending that we have private citizens put solars on their houses to reduce their carbon footprint. But what if all of our government buildings in which we, the taxpayers, are paying for electricity for every government building out there, for every new government building that was built, and when I say government building, I'm talking about Walton County buildings, or they get a new roof on. Every time I go by a school, every time I go by a public building, a Walton County building, I see all this wasted real estate on that roof, and they've got really nice metal roofs up there, lifetime roofs, that are perfect for securing solar panels. And then we could take the money that we've been spending on utilities, on electricity, and put that toward something that we could use for improvements like infrastructure. So do you think that's an idea? And as far as I know, and I could be wrong, I don't think there's a county in Florida that is doing this. I could be wrong. But if we were the first to require our government agencies to put solar panels on the roofs so that the citizens don't have the added burden of paying the electricity bill, is that something that you think could fly? Or is that something that they would say, I must have gotten me a prescription for medical marijuana? You know, what do you think? I'd like to hear y'all weigh in on this.
I don't think it's a bad idea. I just don't know that this is the proper place for it to start. I think that, and I'm asking you guys with the county this, there's a process that those kind of ideas should go through before they get to us. Is that correct? That would
assuming it ever gets to you, that's the kind of,
before it gets to us.
well, I'm saying some of the, like an idea like this may not actually have to come before the planning commission. It's one that would probably be a BCC level determination, but it would work through the staff process. So it's not even really a planning level consideration.
Right, but it would.
Because you're not putting a policy out there for everybody to put it on, and you're certainly not saying that all governmental buildings, which would go beyond just the county itself, would have to have them. Rather, you're proposing the county itself self-impose solar on all new buildings, if I'm understanding you correctly.
Yes.
So really, that wouldn't be a regulatory issue for the planning commission.
But it would usually go through a process before it gets to us, correct? And I mean, it would have.
Oh, absolutely. If it was ever to come for you, it'd come through the staff level first.
Yeah, so for an idea to be generated like you're doing here, it should start somewhere besides here.
So, Mr. Jones, would I get requests to get on the BCC agenda and present this to them? Is that how this works? Is that the way you would recommend? And before I put myself out there, what do you think?
Good idea.
Yeah.
If anyone comes before the board with a specific recommendation in mind, BCC says, we like that. Staff develop us a policy that says, henceforth, all newly constructed county facilities, whatever that may mean, will include solar panels for electricity. We have our marching orders. We write a draft policy. We take it back to the board. Commissioners, is this what you were looking for? Yes, sir, that's correct. That's what we had in mind. I make a motion, we adopt it. Second and 3 votes, and it's done.
Yeah, that wouldn't come through us anyway.
Well, there may be a scenario where it would. The board
Some
may.
policies could,
Yeah.
yes, certain issues. This one probably not, but yes, some could. So you may see it again.
Well, I mean, you saw the wetland transfer issue. They said planning, do some workshops, do some investigation, do some studying, take it to the planning commission for a recommendation. To the planning commission, they recommended that you deny approving this policy, change the comp plan, whatever it may have been.
So,
But that is a policy issue that certainly can be made at the BCC level at their discretion, typically through staff interaction and a draft policy to attempt to accomplish what they've asked us to do.
okay.
You see that?
So could I ask, just for informational purposes, that we take a straw poll, show of hands, who
No,
would be?
sir, I can't let you do that while you are in public, and so we are subject to sunshine and we're protected. The reason I can't let you do that is, even though it's not an official action, you're still taking a vote on an item that is not on the agenda.
Okay,
And so we don't take, and I understand it's not official action, but if somebody would ever say, well, the planning board approved this and they pull out these minutes, well, that's what they're relying on. I don't want to put you or the board in jeopardy of an issue. And then
Yes,
the
sir.
other reason, Mr. Cosin, that I would ask you not to ask the board to do that and ask the board not to take action on it is this. Let's say you go before the Board of County Commissioners and they choose to move forward with this idea, and then somebody starts opposing this idea. I don't know why, but people oppose ideas. It happens. I don't want some procedural foul down here saying, well, he did it wrong at the planning board, brought it up, had him vote on it, said it was just a straw poll. Next thing you know, he's at the BCC telling them the planning board liked it. That's the kind of thing that could get everybody in a procedural foul and stop a good process or good progress.
thank you, sir.
The one recommendation I would make, and Counselor, if you go before the Board of County Commissioners on an agenda proposing this policy, it should be Mr. Cosin as a citizen,
Yes, sir.
not as a member of the Planning Commission.
Well,
Absolutely.
and that's the other reason why I don't want it to be, hey, I started it here at this level, so there's no question of, hey, I'm doing this as a planning commissioner, and somebody says, well, wait, as a planning commissioner, that's not really what you're supposed to be doing. You know, sometimes, you know, the old expression, the road to hell is paved with good intentions, comes into play. And so understand, we're trying to help you out here, but I agree with Mr. Jones. I certainly would say either on the agenda yourself, and there are other options, of course. And certainly, there's nothing prohibits you from talking to, say, for instance, the commissioner appointed you to this board and saying, there's an idea I have, and a commissioner can always put something on the agenda if they want to advance it. Can't go take a straw poll of those guys either, but all it takes is one person to put it on the agenda.
Yes, sir.
So
And-
two options, yourself, and I believe, correct me if I'm wrong now, I believe if it is an item they want action on the BCC agenda, it needs to be submitted as a formal agenda request with the documentation. So no different than, I know you've been at City of Funiac before, we have that citizen comment section of the agenda. We can't take action there, but if you get a request to be on the agenda, you can.
Yes, sir. Y'all answered my question. Thank you.
Good?
Yes, sir.
All right, I guess we're adjourned, right? All right, we're adjourned. Except for the donuts.